Okay, so this is succession law, workshop number 7, and this week we're focusing on ambiguous wills. As we've seen previously, there's a lot of common law and more particularly statutory law that looks at fixing ambiguity in wills. This is just a recap of what we've looked at previously. There's the common law principles tend to be that a will is a bit more like a contract, that it's upheld, or it stands or falls on its merits and how well it's written. But there's been a whole lot of law reform in this area and a lot of statutory provisions that have been designed to prop up wills and to avoid intestacy. In fact, the golden rule in this area seems to be avoiding intestacy. Okay, so the purpose of this week's workshop is to start talking about, well, what do we mean when we talk about ambiguity and uncertainty in wills? There's a lot of it in the legislation. There's a lot of discussion of when it's ambiguous, we do this, we do this, we do this. We look at the original intentions. Remember, we can also look at extrinsic materials and everything else. So what are these ambiguities that we're trying to fix? I asked you last week to have a bit of a think about that beforehand, and we could start mapping some of those out, looking at things that have happened in the cases and things that might have occurred. That's what we'll do. And hopefully I've got a bit of mind mapping software queued up, and we'll be able to use that to establish exactly what sort of things fall into that ambiguity. So before we start, as usual, want to briefly talk about the readings to make sure everyone's cool on the readings for this week. Make sure everyone's understanding the material. As usual, there's not a lot that is very complicated in succession law, which is nice because we get to look at some of the practical issues and we look at some of the practice issues, which you often don't have much of a chance to look at if the law itself is kind of weird and complicated. There is weird and complicated law in succession, and next week we're going to look at ademption. I think it's next week, and ademption is weird, and that's where a gift lapses because the gift doesn't exist anymore, and there's some really strange arcane law in there. But again, most of it's been kind of moved, sort of circumvented by statutory change, which is quite nice. All right, so the reading for this week was chapter 8 of the textbook, which is not as short as the previous one, but it's still not all that complicated. As usual, this is not a lecture. This is not me going through the chapter in depth, but I'll just talk through some of the issues in it. And by all means, I'll chuck up the chat window as well. If you've got any questions along the way, feel free to interrupt or chuck something into the chat window and see. So chapter 8 is on construction of wills. And you'll see here immediately, this is where the connection to the workshop on ambiguity is. And the example I give straight away right at the very beginning of the chapter is, I give a gift to the Wilderness Society, and the question is, which Wilderness Society? So when we're looking at construction, I guess it's got to be about ambiguity, because if the will isn't ambiguous, why would we even look at it? If it's clear who a gift's going to and what the gift is, it doesn't actually end up being an issue for the law. Okay. There's a little bit of stuff in there about the difference between the court of probate and the court of construction. Hopefully that's clear that a grant of probate is separate from the process where you get into the actual construction of a will. We've looked at that previously. Again, if it's any of that's unclear, we can talk about that some more. The bulk of the chapter is looking at the principles of construction. You'll have seen these before because these are statutory interpretation rules in a slightly different context. But you'll find one of the nice things I think you find as you start getting experience as a lawyer, as the same principles pop up again and again, and you get more of a sense of legal process being coherent and having a set of uniform principles that run through different areas, even at things like interpreting a constitution and interpreting a will, seem quite different, and we deal with them quite differently. The same principles pop up again and again. Is there anything particularly new and unusual here? I don't think so. They look at things, words with unusual meanings. One of the things I think is quite interesting is they allow a particular individual dictionary for the testator. So they allow you to if an individual testator refers to something in a way different to the ordinary meaning, you can actually bring in evidence to say, oh, but they always do that. Tricky to find an example of this, but just say someone thinks they belong in a 1950s gangster film and they always call money clams, and they give 10,000 clams to their nephew in their will. Okay, it's a stupid example, but the law would allow you to actually bring in extrinsic evidence and say, we're not actually talking about actual clam. We can actually look at this person's individual dictionary, so to speak, and say that they always call money clams. I don't think you get that I'm not an expert in contract law. I don't think you get that in contract law. The big difference, I suppose, is you can't actually bring in the person who drafted that section and interrogate them before the court like you can with contract, because, of course, they're dead. There's stuff on customs and communities. This is little red flag for your assignment, because if you find that a particular community, particular group in society, religious or ethnic group, have particular customs and forms of expression, and that's reflected in the will, there's a way here of actually bringing that in. The golden rule, the avoidance of intestacy. Some more Latin there for you. I don't know how much Latin you did in statute interpretation. That was just probably the most Latin I did in my entire law degree. And I still vaguely remember Justum Generis and Noscitere Socis and all those kind of rules. And here we go, Justum Generis again. And of course, I love that the fact there's a rule called the Rule of Despair, which sounds like a World of Warcraft expansion. Okay, so there's a section in the book too on extrinsic evidence, when you can bring it in. Common law, there was limited ability, and of course under statute there's much broader ability as well. So you can see there's a whole lot of effort or reform energy put into actually being able to understand wills and actually be able to interpret them and uphold them, which is good in practice, but I guess is no excuse if you're a practitioner drafting a will. If you see any of these examples, these are things that you just should avoid anyway. It should never be a situation where people have to go to court and start trying to bring in extrinsic evidence of what someone means. The executor / personal representative should be able to do that straight away from the will. They should be able to understand completely. Okay. There's the statutory stuff on extrinsic evidence in there, which apparently South Australia is different. So again, if you're in South Australia, which I don't think any of you are, take note. If you're not in South Australia, file that away somewhere in the memory banks. If this ever comes up, make sure that you check the legislation. Stuff on spouses. That's, I guess we'll talk about when we look at ambiguity, because when someone leaves something to a spouse or a partner, my wife is a kind of an interesting one where people remarry, and of course, what happens when you get married to your wills? Any takers? Yeah, they disappear. They get revoked. Yeah. So when you leave something in a will to your wife or your husband, once you've divorced that person or you marry someone new, in both cases that will gets revoked unless you reaffirm it, in which case the person that you referred to previously as your wife will not be. But if someone is unmarried and they leave something to their wife or husband, meaning their ex-wife or ex-husband, that can become complicated. And if they've got multiple exes, that becomes more complicated again, let alone the term partner, because again, that's going to be something ambiguous. If someone means partner as in life partner, or do they mean something as business partner as well? Anyway, worth remembering, and also remembering that marriage and divorce revoke the wills. Class gifts, you can leave gifts to a class of people. That's going to be important again next week when we look at how closing the class. But again, that might be a source of uncertainty. One of the big ones is the class closes at the date of death, not at the date of the will's creation. So if you leave something to my grandchildren, the grandchildren who are not yet born but are born by the date of death will be included in that. Now, there's some material at the end of the chapter on property. It's only a couple of pages where it basically says the will speaks from death as to property, which means if I leave someone my car, it's not the car like the class rule. It's not the car I have now when I create the will. It's the car that I have at the date of death. Now, that's a very simple version of that issue, and next week, which will be a few weeks away now, because the consensus last week was that you guys weren't keen on coming back and doing a tutorial on Christmas Eve. I don't know why. I would have done it if you really wanted to, but I wasn't very keen on doing it myself. So we won't be. The next week will be a few weeks away. I'll talk about that at the end. But anyway, the point I was trying to make is there's a little bit at the very end of this chapter on property. Good to know, but don't go. But we'll be returning to that issue, particularly the when you talk about a piano or my piano and those sorts of technical differences. So stay tuned. We'll do more on that. The other thing, probably not the right point in time to mention this, but there's a whole lot of stuff in the start of the next chapter about knowing the difference between bequests and devices and things, which doesn't go anywhere. So if you're reading it, you're starting to get confused about what's a device and what's the difference between these things. The textbook, again, I think because it's a rewriting of an earlier book, it makes a whole fuss about the difference between these things and then goes on to say there really isn't a difference between them. So just skip over that stuff. You probably find this a bit of a problem. There is a problem with law textbooks. They do spend a lot of time talking about things that aren't law anymore, and that's because it's very hard for people to let go. And things you learned as a law student that have all been taken away by changes to the law. You still want to teach the students that stuff because if you had to learn it, they should have to learn it. Maybe the law will change back one day. Anyway, you have to forgive us our foibles as legal academics. Sometimes we spend a lot of time talking about things that don't mean anything to anyone, unfortunately. Okay, so we're okay with that chapter on interpretation. Now's the time to sort of ask questions while it's still fresh. What I would like to do now is look at the workshop questions. Given the small number of people in the course, I'm not surprised that we haven't really had the chance to actually. I don't know if anyone has managed to draft up any uncertain clauses, but I thought what we could do is we could just talk about what things could be uncertain, and we'll put it on a mind mapping screen if I can get this to share. If that sounds okay. If I hit share screen and go into Chrome, it now asks me a whole lot of passwords. All right, can we see that?
Yes.
This is all new for me. So this is a online a mind mapping service called Coggle, which is nice and easy to use, and you can share it, you can save it, and you can do all sorts of things. So it's quite useful. Okay, so what things can be ambiguous in a will?
Scott, I looked at a case today, Parkinson and Diabetes Australia. It was a case in where the issue was the correct identity of the charity that was to receive the benefit.
Yep.
And the charity was basically Diabetes Australia, but there was a Diabetes Australia and then there was another one, Diabetes Australia New South Wales.
Yes.
So that was actually quite interesting. So that was basically about if there are two or more charities with similar names, then further questions need to be put to the testator and to record their instructions as to the identity of the charity.
Right. Exactly. So I've put a note in there on that. One of the things we'd look at is the identity of the beneficiary. And one of the things that can create a problem's identity is multiple organisations, such as charities, I might say with the same name or with similar names. Now, can I make this? No. See if I can make a page break in this. I'm sure there's a way of doing it. Anyway, doesn't really matter. Okay, so that's probably a relatively common occurrence, and it's usually I think it's going to happen where the testator doesn't know that they're referring to an organisation that has similar names. It also occurs with organisations where they change their names. And sometimes that can happen because they're organisations with the same name. So you might want to leave it to your local branch of a particular organisation. They are having scuffles with, Multiple Sclerosis Victoria, or are having scuffles with Multiple Sclerosis Australia because they have similar names. Multiple Sclerosis Victoria changed their name to Mobility for MS Victoria. And then you've got a situation where the will is for Multiple Sclerosis Association. The Australian one looks closest, but what the testator actually intended was the one that's changed its name completely. And then you've got to be able to try and establish the chain of changes there. So it's now begging for money from us. It's one of those funny, not so funny things that where you end up with charities squabbling over wills. It's not a good look, but sometimes these bequests are a lot of money. Could also be corporations. And let's maybe put that as another branch. No, don't do that to me. Okay. What I wanted that to be was up here, which means I needed to put it there. I'm looking vaguely competent, or not. Part of the problem is, of course, my video windows are sitting over my shortcuts. Anyway, Alt and click X is to remove. Just like a bought one. Okay, so Actually, that's not so. I was going to say organisational change of name. The same thing can be a problem where a person changes their name too. Okay, while we're either on the issue of beneficiary or other forms of uncertainty, what else might we put on this? Any ideas?
Well, wouldn't there be still like an identity of the actual gift as well? Like if
Yeah.
you're saying, I leave my wedding ring to such and such, well, you could have another wedding ring from your previous marriage. So
Yes. So we've got a whole field here. Let's make this look a little vaguely nicer. Whole area on property. Say multiple items in category, where you've got a category of property you want to leave and there are multiple things it could apply to. Yeah. What else could happen? Any ideas? Again, there could be other problems with property. What if the property doesn't exist anymore? Should the executor buy? If you say, I want to leave someone my Ferrari, and you've managed to crash your Ferrari, or you've sold it or whatever, does the beneficiary still get a Ferrari? So let's say property sold or lost. And yeah, next time, we're going to do a lot more on that. That's the doctrine of redemption, which has its own particular area. But yeah, I guess the short answer is, if you say, I leave someone my Ferrari, and it's been destroyed or sold, they don't get it. If you say, I leave them a Ferrari, and there's enough money in the estate, then the executor goes and buys you a Ferrari, which would be nice. So yeah, that could also be uncertain whether the property is something that doesn't exist anymore, and then if it doesn't exist anymore, are you entitled to replace it? I would also add on to that, and this is kind of a combination of both those two sections, is this new property with the same description. So if you say, I want to leave someone, an example is, one of the cases is my piano, and then you sell that piano and you buy a new piano. Does the person get the new piano? And the answer is in that one, again, flash forward to next time, is an unsettling maybe. And the cases seem to go either way on that one. All right. What else might be uncertain around or ambiguous around property? What kinds of property, might be difficult to identify, or might be something that changes from time to time?
Shares could be difficult to identify.
Yes. Shares are a big one, and they may not seem to be on the face of it such a difficult, particularly if you say, I leave my sister or my shares. But shares are always subject to change and corporate reorganisations and corporate restructures. So you've got to be very careful with how you describe shares, because the shares even at the date of death might be different to the shares that exist by the time the will is executed, particularly if there's been a long delay in execution because people are challenging the will or whatever. In the meantime, corporations undergo restructures, or agents may buy and sell shares. So shares can actually create quite a headache under a will. Now, I've not seen how you deal with that. I'd be very interested to know how what solutions people have come up with that. I mean, one thing may be an immediate instruction to sell your shares on the date of death, so the executor sells the shares straight away, so that there isn't uncertainty over them. I don't know. Then again, you may not want to liquidate shares; you might want to give them to people. The next workshop we're actually going to look at, and there'll be a little bit of homework for next time, looking at different forms of structures and organisations that you can use to that you can create under a will. So things like trusts and corporations, where you don't want to just give a beneficiary something, you might want to create a structure where they get given a little bit at a time, particularly if they're minors. Other things that's kind of similar, although you might not think so, to shares is money. I don't think this creates a problem anymore. But there were problems in the past when people said, I leave all my money to Jack, or all the money in my bank account to Jack. And that created some sort of legal question of what is money and what are you describing as money. I think it's pretty straightforward, but there are cases on it. I suspect the cases go back to a point of time where cash wasn't quite what it was today, and people had money that was in legal tender, like banknotes and things, but they also carried around money in the forms of bills of lading and promissory notes and those sorts of things as well. It's all very Dickensian and Victorian, and no one does it anymore. But back when a lot of these cases were decided, you didn't just have, you certainly didn't have an ATM card with PayPass on it. You didn't have just a stack of dollar bills and coins. There are all sorts of different ways of holding currency. So arcane, but I'm mentioning it because it pops up in the cases from time to time as an issue. All right. Anything else that may provide ambiguity in a will? I mean, I know property and beneficiary is kind of all there is to it, but there's a couple of other things that might also, particularly around the beneficiary. How about class gifts? So in the situation, the simple one is all my grandchildren, because unless they predecease you, and that's a separate issue, all my grandchildren is a kind of an relatively easily determined, for most of us, category class of beneficiaries. But then again, there are cases, I guess, and there's always situations where illegitimate children pop up out of the woodwork. And all my grandchildren, you suddenly find out that your illegitimate children have had a whole stack of grandchildren that no one else knew about. So even something simple like children can create a problem. But what if you want to leave something, stranger things have happened to all the people who work in the office with you? When does that class close? If you've retired, is it just the people in the class, that category, in that group, who are working with you at the date you retired? Are they the people who continue to work at the local branch of the bank that you worked at? Again, you've got to be very specific about that. Things like theatre companies or charities, other examples. Here's a pool of money. It can be divided amongst all the people who work at the local charity. But different to a gift to the charity, this is a gift to a class of people determined under that class. there can be ambiguities with how you define that class and when it's decided who's in or who's out of that class. Now we're drawing on very, I won't say esoteric, but unusual wills where this would happen, but it does happen from time to time. There are groups of people in maybe military regiments or people who they're close to, or groups of friends who it would be much better if they just defined them by name and said, here's a list of people, dividing up amongst those people who are still alive at the date of my death between them. But sometimes people like to set a more general class. And I guess having a general class is allows it to evolve over time. So if you've got your local charity that you work at, local soup kitchen you work at, people come and go all the time. You don't want to have to keep adding names to a list. You might want to just say, here's a sum of money and we split up with the people who work at the soup kitchen at the date of my death. So that's something to be cautious of. Class gifts can create ambiguities. And the last one I want to mention is not one that the textbook really does a lot with, but I would like to mention on it, which is conditions on gifts. Just makes a little slightly nicer. It's not going to win any artistic prizes, that's for sure. So the obvious, what kind of conditions do you think you could put on a gift?
Well, is that like saying you're going to leave something to somebody when they turn the age of 21?
That's the obvious one. But you can really add all sorts of conditions. In the past, it's been things like, as long as you finish university. You think you got pressure on completing university yourself. Imagine if you had a substantial legacy riding on finishing uni. That would certainly be an incentive to get things done. But you can really create any condition you like. And because,
when you marry?
Sorry?
When you marry?
Yeah. That's another great old-fashioned one. Yeah, because you don't want to leave money to your daughters because they'll just spend it on something silly. So you leave it to them when they get married so their husband can spend it. That's very traditional provision in wills. I don't think it would fly today. Although if you did, I suppose it's up to the client if they want to do that. But yeah, when you get married is another great Dickensian old style will condition. What was it in Great Expectations? It wasn't a will, but it was a gift that was subject to him not ever inquiring into the identity of the person giving the gift. I'm probably boring you stupid if you're not a Dickens fan, but Dickens is full of weird legal things because he was a journalist and he spent a lot of time reporting on the courts. He saw lots of weird stuff in the courts, so there's always these interesting little things that pop up. And you could do, as was done in Great Expectations, a gift that was subject to you never inquiring into the identity of the donor, and then you lose if you start asking questions as to who that is. You could potentially lose the gift. That, or you take the gift and then you inquire afterwards because there's nothing they can do about it once you've actually the will's been executed. That stuff becomes also, I guess, important to next week when we look at things like trusts and companies, because how can you actually set up something like a trust and stick conditions in the trust to dole out the money in small amounts and under conditions and still control people long after you're dead. So we're going to look at that quite critically, because on the one hand, as client-oriented professionals, we do what our clients want. On the other hand, there is something vaguely creepy about people whose whose plans include controlling their relatives and loved ones long after they're dead, and ruling their lives. And some of these things are things that the courts overrule. So yes, you get it when you get married. One is one of them, but there's also ones where you get it. You get a sum under a trust each year as long as you don't get married. As long as you don't do this, as long as you never move out of the house, as long as you look after the cats, as long as you do this, that, or the other. And then it becomes a discretionary matter before the courts quite often as to whether they're going to continue to require those conditions to be imposed. I have heard of elderly people who have a gift from a spouse under a will, as long as and it's delivered in the form of a trust, as long as they never remarry. Who then have to kind of do things to get around that. If they meet someone else, they've got to then sort of keep the relationship secret, because then they might potentially lose the money under the trust. Now, I think there's a question of equity there, and I think there could be every chance of overturning that. But I've seen that pop up a couple of times where you've got these strange, controlling, restrictive conditions under a will. For this, anyway, that's for next time to start thinking about those things. We're not going to look at that in a huge amount of depth, because this isn't a will. This isn't a trusts and corporations course, and I'm certainly not an expert on trusts nor corporations. However, many of you will have studied that much more recently than I have, and we can certainly talk about that in general terms. And what I would like you to do before we meet up next time is just have a bit of an explore online and to look at particularly the products that people are offering, the firms are offering. What sorts of things are there out there that people might want to acquire for themselves as a structure, as an organisation to administer a will? And yeah, trusts and corporations are the primary vehicles by which we do that. And we do that to control our loved ones when we're gone, but we also do that for taxation purposes. A few of you are in Queensland, and I think Queensland either doesn't have death taxes or has fairly minor death taxes. But in the rest of Australia, we have significant death taxes. And sometimes what you do with your money under a will is to try and preserve as much of that money from the tax office, so that your beneficiaries get more of it than the tax office does. So that's also going to be relevant. Again, something it's not in the curriculum. It's not something the textbook talks about, but I think it's quite interesting. And given the law in this area is fairly straightforward, let's spend time on those interesting things that are going to be useful to you in practice. All right. So, do we have any? I'm just going to have a look here. I had a couple more points on conditions on gifts. So one was conditions met prior to death. And that's just really talking about the conditions that may or may not still exist at the time of the type of execution. So if it's when they reach age of maturity and all the people in the category have reached age of maturity, it's not exactly something that creates uncertainty, but it can create. It's something you have to think about in the construction of the will. Conditions prior to receipt of gift, and trusts and constructive trusts, where you don't formally set up a trust, but basically the structure of the will is such that you're basically asking. Your intention is to ask the executors to set up a trust. Okay. Anyone think of anything we've missed there? I'll try and figure out what I did in terms of zooming. Now I've zoomed out completely. How do we zoom, guys? What I will do is save a copy of this and upload it to Moodle. So you will have access to a copy of it. That sounds all right. One of the things that's kind of nice about Coggle is that you can actually make these open to share with people. So what we could have been doing, although for this purpose it just wasn't worth the effort, was I could have made this open and you guys could have all been typing things in yourself. So not way too much effort for what we wanted to do here. But if you're thinking of using this as a presentation tool in your own work and things, have a look at some of those options, because it is kind of nice if you're brainstorming things to actually provide the opportunity for people to say, okay, here's a URL, you can log in. I think you have to have a Google account to use it. But then people can log in and they can say, how about this, how about that? They can move things around and things anyway. That's by and by.
I've got something, Scott. It's more to do with maybe the residue of the estate, opposed to specific gifts.
Yeah.
Meaning, say, for example, if a testator wanted to leave their residue in certain percentages and all of those percentages they added up to more than 100%.
Yeah, brilliant. Thank you.
How did they determine what shares each beneficiary was to receive?
Yeah. Okay, I'm going to put residue there. I'm going to put portions as one part that may be uncertain. Move it. It's looking like a railway system at the moment. Yeah, that's a good one, actually. There can be all kinds of problems with the residue. And there's a whole section, again, we're going to look at next week, about where someone's promised something under a will and they get basically an advance on the will. How do the courts interpret that? And unfortunately, again, it's inconsistently. So you say, I give my estate in thirds to all my children, and then one of your children's facing financial difficulty, and you say, I'll give you $10,000 now of your benefit. Now, does that come out of that portion at the end? Yes or no? And it's not necessarily clear. It depends on how you express it. And the really tricky one is what happens if you give one of the children $10,000 and their shares are only sort of $7,000? Does the person who get the advance then owe the other beneficiaries the extra on that? I don't know that ever happens, but you can imagine there's going to be a lot of very angry people if they find out that one of their siblings has basically taken their portion of the benefit under the will. So yeah, I think there could be other scenarios where the residue might be problematic, but as you pointed out, the clear one is where someone leaves 30% to someone, 30% to someone, 40% to someone, and then 20% to someone else. And that's 120%. How do you actually assign those portions? Interesting question. I mean, what I would probably do is add them all up and then divide them all proportionally under each portion, so that the shares were all the equivalent size in respect to each other. Does that make sense? That you made that 120% down to 100% and reduced each of those shares accordingly. Okay.
Another one as well is, say, for example, if they're going to leave a specific gift of cash, they might put that cash sum in words and then a different value in figures.
Yeah, where will we put that? Let's put that in a property somewhere. because that might also include the situations, because you can have all sorts of attachments and things to wills as well, and you might have like a spreadsheet or a table that divides things. And if you say, I leave my my Chrysler to my son, and then you've got a table somewhere that has all the property divided and who it goes to, and it says, you've got your BMW next to the son, like which one do they get? So yeah, there can be inconsistencies within the one document that a good drafter will pick up on. But of course, a lot of wills are not going to be drafted by a professional. They're going to be done by an individual, and then you might end up either being an executor or advising an executor who says, well, what do I do? My tax accountant has retired, but he was telling me he's come back for retirement to become an executor on an amazing estate that involves just boxes and boxes and boxes of documents. That there's a will that refers to documents, and then under the will there are documents and more documents that are not organised, that are all just sort of stuck together. There are various pieces of property, various shares, various interests. He's loving it because he's that kind of person. And I think I can kind of see the appeal for it in sorting that order out of chaos. But it's nice to have a will where everything's clear, but he's got a situation where he's just got a will that includes boxes of things that need to be sorted out. So yeah, I hope that kind of covers what you meant, that the will itself might have property described differently or gifted differently in different sections of the will. Okay, I think that's looking like a fairly good mind map myself. And again, it's not something that the textbook really goes into any depth, but because of that, it's quite a nice little exercise for us to go through and to think about. So okay, when we hit those sections again, when we hit sections of legislation or cases where they talk about if there's ambiguity in the will, the court has the power to correct the will, or court has the power to draw on extrinsic material to determine the intentions of the testator. We now have a bit of a framework to think about, and we now have some ideas of what those things might be, rather than talking about it in sort of abstract terms. So I'm hoping that's going to be useful.
Another thing that I find that sometimes can be quite ambiguous is when you have a life interest in a will. Sometimes it might only be a right to reside. Say, for example, if they want to sell that property, they lose the interest in any cash or income there on the cash after they've sold the property. As say with a life interest, if you sell the property and they invest the cash proceeds, generally they can get any interest earned on it. But with a right to reside, they lose that effect.
So we'll put that in the conditions on gifts. Life interest is a condition on a gift.
Yep.
Life interest, and let's put a further note on that one on sale of the life interest property. And where that does happen more often is someone sells property with a life interest. Someone gifts property with a life interest to husband or wife, and afterwards it passes to children. Husband or wife becomes invalid, and they have to be put into a nursing home. To get the deposit and the fees for the nursing home, they have to sell the property. To do that, what happens to the life interest and the residual interests there? That's actually a pretty common scenario that occurs these days, particularly with the aging population and the fact that more and more people are being put into professional care as they're older. What happens to that residual money? Obviously, they're people who have the residual interest after the life interest expires want to have access to that. Again, that's something there's going to be cases on next week when we look at redemption. Because ordinarily, in the bad old days, you probably would find that the doctrine of redemption would mean that your interest is extinguished as a residual beneficiary. It's like, well, it's been sold now. You don't have access to it. Courts have come round, of course, and said, no, this sort of thing happens all the time. We have to be able to be flexible enough to allow this to happen. What we certainly don't want is people with life interests being invalid and staying in houses where they can't look after themselves, can't afford to have care because they can't sell their property. The only thing that they have is the real estate, and they can't sell that because it's only a life interest. We don't want that situation. How are we going to actually manage this? And yes, the courts have basically said the people with the residual interest can have what's left after that. And you can imagine all kinds of pretty nasty family dynamics that can be sitting underneath all of that, with people with relatives in nursing homes waiting for them to die before all their residual interest gets chewed up in fees, which would be very, very unpleasant to be involved in, even just as a lawyer sitting at the edges of the process watching that. Okay, yeah, another excellent thing to bring up and put in there. Okay. Well done, guys. As I said, I will print this out. Not print this out. I will make a PDF copy of it, upload it to Moodle for your edification. You can print it out and frame it if you like. Proof that you've achieved something this week. We're running out of time already. I guess I should make a couple of minutes available for questions, either relating to this week's work or more generally about the subject and assessment. I've had a few of the quizzes in to grade, and I will make sure that the residual are all graded by the end of the week, so you know where you stand. Your assignments are coming up, and I haven't had many questions on it, so you guys seem to be getting along with that. I've had a couple of questions about the format and whether it's to be written as an academic paper, and honestly, if you mean academic in terms of referencing, yeah, by all means, if you've put things in there, make sure you reference them. But in terms of genre, if you think about this being an advice you're writing to colleagues, so for instance, you're living somewhere where there's a large Somali community, you're writing about the Somali community, this could be something that you're giving out, that you're putting on the office file saying, if you have clients who are Somali and you're writing wills for them, here's some tips, some pointers, here are things to consider, and here are things that are important. That's the kind of thing we're aiming at. So yeah, by all means, make sure everything you put in there is properly referenced, and you might not do that in a normal advice. If you're just writing a normal advice to colleagues in the workplace, you probably wouldn't put that effort in, but because it's for marks, make sure you do that. But in terms of the assignment, don't worry, don't stress too much about it being like a theoretical academic piece, because I really wanted this to be a practical piece, and hopefully one that was more interesting and engaging than me asking you to trace the history of the doctrine of redemption and the influence of equitable principles on redemption, because I'm damn sure I wouldn't want to write an assignment like that, let alone mark a lot of them. Anyway, timetable wise, the university closes next Wednesday, and that's Wednesday the 24th of December, and it opens again on the 2nd of January, which is and I will be back. I'm not taking any extra time because we kind of have to keep plugging on with succession law, as well as numerous other things. And the assignment is due on the 5th, which is the following Monday. So I'm making sure I'm back on that day, so that if you've stressing out the weekend before about getting your assignment done, I'll be available to answer questions on it. And that means that our next Zoom session will be the 7th of January. So if there are no more questions, I will see you then. Otherwise, you've still got a few days to send me emails and get in contact before the break if you need some help. Okay?
Thanks, Scott.
Okay. Good evening to you all.